Hello and welcome to Talk TV. I'm your host, Doug Brendel. Tonight we have a candidate for judge, Nancy Lord. Nancy, how are you doing tonight?
I'm doing fine, Doug. How are you?
I'm doing just great. So, Nancy, you have quite a career as an attorney. How long have you been an attorney?
I've been an attorney now for almost 15 years. I graduated from Georgetown School of Law in 1990. Before that, I was a medical doctor, and I spent a few years with a drug company and then another few years as an expert witness where I found that I really liked going to court and enjoyed litigation, and then went to Georgetown in my 30s.
Wow. So, regular MD?
Yes, I have, and I actually still have a legal law license in New York. If I wanted to go back and practice medicine, if I paid the fee, I could legally be a doctor there. They have a policy that you're licensed for life.
Wow.
Yes.
So, how many cases have you been involved in throughout your career?
Hundreds of cases. I've had hundreds of cases, at least 15 jury trials, some of them federal, some of them state, all over the country. Because I had the good fortune that in 1993 I tried a nutraceutical case in New Mexico, and that led to cases coming in from all over. Probably thousands of actual criminal counts, and also a good number of civil cases, personal injury, other types of litigation, and family law. Here in Nevada, I've done a lot of family law. My lack of conviction rate is excellent. Most of my cases, my clients went away without conviction. And my civil cases, my civil defense work is nearly flawless. None of my people have paid more than $1. And that was an offer of judgment that we made.
Wow, outstanding.
Yes.
So, what is it that got you motivated to run for judge after being an attorney all these years?
Well, there were people that asked me to go for the appointment because I was a very close second in the Republican primary for district attorney. But I was nervous at my age to jettison my practice. I really love it. I love my clients. It's interesting. And I was nervous about getting rid of it only to have to go back and be elected. And then I went to court. And I'll leave out the rest, but I decided that Nye County would be best served by having Nancy on the bench.
Oh, cool. So, you're going to be running against Kim Walker, correct?
Correct.
She currently holds that seat?
That's correct, Doug.
Okay, very good. Will you be a drug court judge if you do have that?
Absolutely. Not only will I be in the drug court if Judge Lane wants me, but I would like to institute a mental health court. I have several people that I've represented who, because of their legal prescription medicine, were ineligible for the drug court. And I don't like to see those folks deprived of that opportunity. The problem, I'm told, is that the level of testing that they're capable of doing cannot discern the difference between the legal doctor-prescribed use, say, of something like Xanax, and the recreational use that somebody is not supposed to be doing. Well, there are tests that are available that can make that quantification, and they're findable and they can be found reasonably. And given my background in pharmacology and particularly psychopharmacology, I feel that I'd be very well suited to assist in that area. My training when I was with the drug company, when I worked for the drug company Abbott Laboratories, I wrote a new drug application on a benzodiazepine hypnotic. It's called Solar, something like that. I could have the name just a little bit wrong. But anyway, it was a Stazolam, and that was my drug, and I got it approved with the FDA. Yes.
Nothing like the one that has people driving cars and cooking food at night.
No. I think that's Ambien.
Yeah, Ambien, there you go.
Yeah.
I'm staying away from that stuff.
Right.
So basically, what is the role of a judge in your mind in the whole judicial process here in the United States?
Well, I believe that Justice Roberts put it very well when he said, a judge is to call the balls and strikes, not pitch or bat. And that's very well put. The judge should be completely unbiased. You should come in there with no decision made as to who's going to win or who should win. Very important that you keep a neutral persona, because to a jury, the judge is the most important person in the room. And a wrongly placed comment or even a look could change the way the jury perceives either a defendant, the state, or one party or the other. You know, if a judge sits there and rolls his eyes while a defendant is testifying, the jury is not going to believe him.
Oh, yeah.
And the jury's kind of looking for the judge to tell them what to do. You can't. You want to give the jury all that they need, all of the knowledge in terms of your instructions, even sum up the facts, who said what. But it's not for the judge to say who's telling the truth. That's for the jury. The jury is the trier of fact, unless you have a bench trial. Then the judge is the trier of fact. I've also had the experience of several bench trials, and that's a very powerful experience too, because there's things that you don't need to bother with quite so much at a bench trial. You don't need to worry about prejudicial evidence. A judge knows how to exclude it from his or her mind. In a family case, you don't uphold the rules of evidence quite so tightly. You don't ask for a custodian of records just to bring in bank records. The judge wants to know if somebody's taking money out of the bank account. You don't wait till you can get the custodian of records to look at the bank records and see that maybe somebody was stealing.
So really, miscarriage of justice isn't necessarily a conspiracy. A lot of times it's just inept or...
Yes, sometimes it's just not knowing or not... you have to. There are things you have to know in your bones so well you don't need to think about it. Most of the time, you'll get a brief, you'll get an argument, issues will be raised by an attorney. Sometimes you don't have that opportunity. There was a case in Michigan where my client chose not to take the stand. Many attorneys, most of them know that is a decision the client makes. But I don't know that they all know that the prosecutor cannot comment on it. It was from a very bad case where the prosecutor went on and on about, well, this defendant would have known why the blood was on the staircase, and he could have explained this, and why his fingerprints were on the weapon. And it was a reversal because that got in the way of the defendant's right not to take the stand. Well, in my case in Michigan, my client didn't take the stand. And the assistant U.S. attorney just started to go there. She said, he knew that. And that Michigan judge, without saying a word, nothing's in the record, just opened his eyes real big and looked at her. You're like, what are you doing? And she stopped. He stopped her cold with just an expression. If he didn't know that pit of the law like in his skin, he would have missed it.
And keeping the two attorneys, the prosecutor and the defense, in line probably is one of the biggest things that you have to do, right? Not so much the jury or the witnesses or so much, but making sure that they don't go out of bounds with the stuff that they try.
But usually, again, if a lawyer does something wrong, the other lawyer will object. Now, there are times that the other lawyer can't object. One of them is argument. It's considered very improper to object to an opening or closing statement unless there's something really over the top. The other thing is that when you see the interaction between a lawyer and a client, if it looks like the lawyer is trying to prevent the client from testifying or force the client to testify or force the client to continue a trial when they'd rather settle or force them to take a deal, these are decisions that are for the client. And if you get the sense that something like that is going on, in some cases it might be appropriate for the judge to say, hey, wait a minute, what's happening here? Maybe have the other side leave, and say, counsel, it appears that you and your client are fighting about something. Mm-hmm. Can I help? Because the judge shouldn't colloquy a defendant. That makes them very, feels pressure that they don't need to have. But if you see there's something awry, rather than wait for a post-conviction brief, you can say
the judge can step in and say, hey,
right, yeah,
his best interest might be.
Yeah, exactly.
Yeah. Okay, great. Hey, we're going to take a quick break here, Nancy, and when we come back, we're going to talk a little bit about political views and how they might be playing into it. So don't go anywhere, folks. We will be back in just a couple minutes.